From one point of view, well, it is very simple when we're saying about the defenses in criminal law. Yes, and everybody know that, for example, we know what presumption of innocence means, and that's why due to criminal limp in the European Court of Human Rights judiciary, we have the possibility to find a very huge amount of cases on Article 6 or Article 7 or violations of Article 4 of the 7th Protocol, which are giving us the possibility to defend some people against abuses of power from the state. That's one point. The second point of view, that criminal responsibility is traditionally we're saying that criminal responsibility, that is a relationship, yes, the legal relationship between state and offender, under which the state has the right to prosecute and the offender has the right to be prosecuted, yes, due to what is the material characteristic of this relationship. The material characteristic means that socially dangerous behavior has to be criminalized, and this socially dangerous behavior, the perpetrator of this behavior has to be punished. And that is why, what is the ground of criminal responsibility? You remember, ground of criminal responsibility in every part of our world is Corpus Delicti. Corpus Delicti, with every country as a material element for criminal responsibility, consists of some elements, yes. We're saying about object, subject of crime, object matters and subject matter, or in, well, European legal tradition, or a tradition which is connected with common law countries. We are saying about actus reus and mens rea. I was wondering the one day when we say about mens rea, and the people from the United States of America give a very specific glimpse on the situation when, for example, the idea of culpability should be excluded from the criminal activity. And yes, sometimes will be we'll discuss this theme too when we will just discuss the problem of criminal responsibility of legal persons. But the idea of nowadays lecture is connected with one classical characteristic of defenses. By the way, we have two, not two, well, we have three or more, maybe four. 4 grades or 4 groups of defenses in criminal law or as a whole. You know that due to Western tradition, criminal law means substantial criminal law, procedural criminal law, and preventive criminal law. As usual, we are saying only about substantial criminal law here in this country. That's why we use traditional, and we analyze traditional defenses as the elements of material practice. From another point of view, we have a very, very specific bunch of criminal defenses and procedural. Presumption of innocence from the one point. The right not to give any information against yourself, your relatives, and so on and so forth. The right not to give or not to communicate as a whole on the problems that were hidden by the specific procedures or by the specific subject of state of subject. For example, if I'm a judge and I'm at the process, I have no right to give any information about this process. If I'm a prosecutor or an investigator, I have no right on the age of criminal responsibility for that. I have no right to analyze any information, not analyze, but to communicate on this information. That is the case. As usual, we're seeing about one group of defenses, and we have to analyze it very, very closely in a separate lecture. That is the defenses which are connected with the idea of excluding legality. But let's begin from the beginning. So, what is the notion of crime? Do you remember it? What is the elements of crime? Not the actus reus, but the elements of crime. Remember? Yes, of course. So the elements of crime is social dangerousness, yes, predictability in specific law, yes. From the second point, punishability, well, and guiltiness, yes. These are four elements of crime. That is why, for example, if one element is excluded, there is a defense. There is a case that we are not used for punish any people or prosecute any people. So the first one group, just we know it, the first one group is connected with the social dangerousness. If the social dangerousness of an act is excluded from the list, some people said that these guys should be defense, and that these guys should be excluded from the subjects of criminal responsibility. In Article 11 of Criminal Court in Ukraine, its second part said that if an act of deviant behavior of an offender is of very, very small social dangerousness, this offender can't be prosecuted. That is the fact. So minor offenses or minor behaviors of some people can't be prosecuted. By the way, this case has two parts. One of them, this material part, and that's why, for example, we're saying about the some of the social consequences which are connected with this idea. The second one is subjective part, culpability. And if, for example, I wanna possess, well, some money from another guy, yes, I take this, I pickpocket this wallet and find that there is no $1,000 but only 5 hryvnias. My intent was to pickpocket a wallet with a huge amount of money, but I has a very small amount of money from the material breach. I have not to be prosecuted. From the characteristics of my culpability, of my intention, I have to be prosecuted, and that's why, for example, I should be prosecuted for my preliminary activity, yes, for the attempt to grave crime, not grave crime, but attempt to theft for pickpocketing. It is understandable, yes? So these are two elements. One, material. The second one is, well, culpable, yes. That's why the characteristics of these two elements give us the possibility to exclude the, well, offenders from the list if their social dangerousness is minimal. That is one of the main ideas of criminal law in this situation. The second, exact of legality. In the year of 2000, the legislator and Criminal Code of Ukraine makes the first time a very, very specified group of circumstances which are given the possibility to people to defend themselves in case of their activity, their socially dangerous activity, is not illegal. Because sometimes we give the possibility to be this activity legal. So we have all the elements. We have the elements of crime which are connected with punishability, because they are done by the subject of crime, which are connected with the culpability, because they're done by the inventors, people, which are connected with the social dangerousness. Yes, but the elements which are excluded, they're the elements, this elements is legal element. What does it mean to us? What does it mean to our situation? What at first? At first, we have one would say about necessary defense. Last lecture, next lecture part, me would be connected with all the elements of these defenses, because it is very, very specific. One could be very big professional to qualify to differ the intentional homicide from necessary defense. What is the limits of necessary defense? Why, for example, I can use the firearms? You know, for example, when we were involved in the last revolution, there was a problems of understanding of necessary defense, and some rebels said that, well, guys, we are defending ourselves, and the principle of necessary defense in political manner, in political way, should be the element, for example, of making the process of mobilizing of some terrorist groups. They say, well, we're defensive. We're working as defenders of our state, of our position, and so on and so forth. I don't know whether it is good or not. That is not our idea to be involved in the politics, from one point. From the second point, we have to analyze it and have to give all the information. Well, it is my duty to make it is more clear to you. What does it mean to defend yourself, state, third persons, or somebody else against socially dangerous acts? What do you have to do in this, when this defense is possible or not? That is the same of next lecture. The same will be the moments which we've been trying to analyze the extreme necessity, when we have to prevent danger by making some threats or making some socially dangerous acts against some people, and so on and so forth. Physical coercion as a defense should be analyzed too. Mental coercion, somebody by psychological abuse coerce people to commit a crime, obeying an order or command. You know, that it is very popular, especially with military men, when they say, when we're at weight of order of our command, that's why we can't be prosecuted. The affordable risk is an element of excluding of criminal notion as a whole that will be analyzed in the next lecture too. And the last but not the least, very interesting position, this position which is connected with a special mission to prevent or to prosecute organized criminal activity. You know that sometimes our agents are working in the organized groups or criminal organizations to be, sometimes they commit petty crimes too. And for these elements, we have to analyze its characteristics, that will be the next lecture. The next element, culpability. Well, the crime or the criminal should be culpable to be prosecuted. If this element is excluded, one can't do that. At what position we have not working with the principle of culpability? These are three positions. One of them that is connected with insanity and the principle of sanity. Well, we have analyzed it during one of previous lecture. The second one is connected with the abuses, alcohol abuse or drug abuse. Sometimes people have to be involved in a very specific situation when they drunk so much they can't understand anything. And at this situation, the pathological drug abuse exclude these people from criminal responsibility because one can say about culpability. Well, we have to analyze it while doing a special medical expertise, psychiatric expertise too, but we have to do that. We have to prove that the better was culpable. Punishability. It's a very interesting moment because, sometimes the judge has to do everything. The prosecutor is doing everything. The investigator is doing everything. But the offender is released from the court. Why? Because they have not been punishable because of their subjective characteristics. Sometimes some punishments should be used only for a specific category of people. For example, we can't use forcible work for juveniles. We can't use forcible work for against pregnant women and so on and so forth. And that's why sometimes it would be a very interesting situation, and we will discuss it too later, when, for example, we are faced upon the criminal norm in the special part of criminal code, when it can't be used for the specific category of people, for example, for against elder or against minors. The sanctions are very specific, and that's why we can't do anything with this situation. So the first category is these are defenses against notion of crime and elements of crime. It is understandable. The second one is defenses against corpus delicti, object, subject side, object side of crime. It is very simple, because sometimes we can't prosecute people if there is no object, because these kinds of activity are not included in criminal limb as a whole. For example, is bureaucracy socially dangerous? Yes, but do we have a bureaucracy as a criminal activity? Did we criminalize bureaucracy? No. Or prostitution? Yes. The exploitation of prostitutes, yes, that's a criminal act. But the prostitution as a whole, the sexual services, are they criminalized? No. We have a responsibility in against prostitutes in our Code of Administrative Offenses, but from the other point of view, there is no object as a whole, because the crime against morals at this position is not working. Object side of crime means that sometimes the deed can be criminalized because it was made with a very specific elements of people's activity. For example, reflexes, or what do we have to do with the lunatics? Yes, sometimes people are making their acts in a specific kind of mood. And that's why we can't do anything with them. Subjects, age or sanity, that is understandable. Sometimes sanity is working against some people. Well, and subject side, that is understandable too, because sometimes culpability, that's the main element. Well, we have a very specific, not very specific, but the specific elements of defenses, which are not, as usual, they are not included in the list. This defendants based on immunities, because some people has the immunity against criminal charges. For example, the deputies, presidents, the leaders of parties, well, judges, the representatives of diplomatic circles, and so on and so forth. They are given the immunity by the state for their independent work. They're not given as a private people. All their immunities are connected with their works. For example, I have immunity, an age immunity up to the end of my life on commenting European Convention, because well, that is one part of my work, and I have a freedom to comment everything which is connected with abuse of powers or abuse of rights doing with the coercive powers of the state. Defendants based on privileges. It's very specific under the defendants. It is connected with the privilege to be prosecuted with a special mechanism. For example, here in this country, we have we're saying that people's deputies are excluded from the defenses, and they have no immunities. But from the other point of view, they have a privilege to be prosecuted only by a general prosecutor signing an act. Yes, an advocate has to be, or the member of the Ukrainian bar has to be prosecuted and has the privilege to be prosecuted only by the regional prosecutor, not by the representative of prosecutors of minor level. Well, defenses based on criminological concept, it's a very specific one. They're very interesting and are not typical for the Ukrainian state. We are not using it. We are using it only, well, in procedural manner when the member of the bar, for example, are saying some words about it. What I have to say, what do you know about, for example, the theory of stigmatization? The theory of labeling, when some people are labeled as a criminal. For example, you're a minor, you're living in a very dangerous situation, you're a member of the gang, and some criminologists say that if you are the member of the gang, you have to behave like the gangster, yes? You have a very, very good ideology. But from the other point of view, you are doing it with another manner. That's why that is the gap which criminologists use. Sometimes they use the characteristics of age, of sanity, the characteristics of illness, or people's health. For example, I have a diabetes, and if I have a special diabetes attack, I can't be prosecuted in the case when I, for example, possess some food for my health. That is an element for doing that. Well, the next and the last part of our activity, where we also be prepared to analyze it more closely. These are defenses based on discharge of liability. What does it mean? It means that the state has the right to discharge the liability if there are some circumstances or some conditions. Among these conditions, this, for example, the case of effective repentance, that after committing a crime, I'll do everything for making my best. The reconciliation of victim and offender, when victim and offender contact each other and offender compensates victim everything. The admission by the bail, the change of the social situation is very interesting. By the way, for example, the change of situation sometimes, or in some circumstances, should be an element when the charges can't be involved and the people can't be prosecuted. Well, the limitation period, that's a typical one, because sometimes people say that we have no right to charge people if there is a special term depending on the stage of gravity of the crimes, which should be passed away for making people not responsible for the crimes. These are the main ideas. Sometimes we could say one more idea. So, criminal responsibility and defense against criminal responsibility have its specific elements in case of preliminary activity, in case of resultative criminal activity, in case of complicity, and in case of corruptive crime. Complicity and corruptive crime on the organized crime and corruptive crime means should be analyzed. What is connected with resultative activity or preliminary activity? It is connected with the defenses based on notion of crime and based on corpus delicti. These are two main parts. Then additional parts are privileges and additional parts are immunities. That's all what I have to say to you during this lecture. Thank you very much for coming. I hope that we'll have the possibility to work together the next time. Well, if you want the previous lecture on complicity and conspiracy is now placed on my YouTube resource. Just use it for preparing. Bye and thank you.